I've got a question. I was going to ask Sandy. I didn't realise you were still here, Chris. But particularly because Sandy mentioned people going after herself and Clive de Carle and not going after Richard so much, and her thinking that might be because of your involvement with UK Column. So with regard to your talk tomorrow, Chris, do you think, because I remember a couple of years ago going through this thing of like, oh, there's all these people doing all these grassroots movements and a lot of them are duplicating, they're doing the same thing, and wouldn't it be much easier if they all got together? But then I realised there's also an advantage because it's a bit like whack-a-mole. You know, they can't get everybody because everyone's... Do you think there's a disadvantage to your plan for tomorrow of bringing everyone together in that you can then be targeted more easily in that way, in the same way that Sandy was saying about UK Column?
Yes, you're quite right in a way, and I think we need the purpose of doing it tomorrow. Let me just clarify again what it was we were suggesting, is to get everybody here who represents a particular group or something, maybe get 20 or 30 people together to plan how we can cooperate together as a freedom movement to ensure that all the things that we're particularly interested in, you know, from climate change to ending war, all the other things, happen and effectively. Now, the important bit is that for the last 200 years nearly, the government and the WEF and the elite psychopaths and sociopaths behind everything have been using corporations to hide behind what they're doing. And they can pick us out as small organizations or as individuals and isolate us, and we have no effect at all. You can see that happening all the time for the last 100 years or so. So what we need is a corporate approach that is as powerful against them as they use the corporations against us. Now, there was a particular legal change in this country in 2014 called the Cooperatives and Community Benefit Societies Act. It came in, I don't know why, but it has come in, and what it does is it gives cooperatives, normally set up with individuals working together in a design group or engineering firm or whatever it is, it gives cooperatives a new power, and that is to have organizations as members of the cooperative at the same time as individuals. Now that's very important because they are limited liability. And they have been avoiding all the criminal liability for everything they've been doing the last 150 years because they claim limited liability. And if anybody's going to get to take it to court, it'll be the managers of the organization, not the owners, like BlackRock and all the rest. So we need to set up a corporate body. And what I'm going to propose is that we set up a multi-stakeholder, limited liability, community platform cooperative, community cooperative. And that will provide us technically with the same abilities as the biggest multinational organizations to bring our own rules into effect. And if we have them, for instance, within a local town or a council or whatever it is, and we substitute this for what's going on now, we can make the rules. We have the power over our own taxes and money. We can start to bring about the changes we really want to bring about and bring about them rapidly in a systematic way based on new systems that will automatically change the way things go on. So I'll give you one example of that. At the moment, we have a minimum pay act, minimum salaries or wages act, don't we? At the moment, why don't we have a maximum one? We don't want people earning 100, 200, 300 times more than everybody else. We want to ensure that in our particular community, nobody gets paid more than 3 times the minimum. Whatever happens, and we can bring in these rules and enforce them locally. We can bring in a huge amount of number of systemic changes into society if we plan it carefully and we use the structures they've been using against us, against them. So that's the basic underlying principle of it all.
Who would be the stakeholders?
Sorry?
Who would be the stakeholders in that?
Multi-stakeholder gives us the ability for businesses, so we could, for instance, ask Shell to become, say we had a round here, Shell and BP become members of the organization or Big Pharma, but they only have one vote, as do each of us. So that it brings their power right down to almost zero, equal to us. So if a business wants to, say a petrol station wants to be a member, then they have no further power over us locally than their vote in annual general meetings or extraordinary general meetings or whatever we set up within the locality. So it is important to understand the different use of the word stakeholder.
Stakeholder capitalism, which is a really big issue.
Absolutely, it is important.
Somebody wants to ask a question? Here.
So I just wanted to ask if you could repeat what you said.
Oh, right, yes, it's slightly
14.
complicated, but basically the law was the Cooperatives and Community Benefit Societies Act of 2014.
Cooperative and communities.
Cooperatives and Community Benefit Societies Act of 2014. You can find it on the government legislation website.
Lovely, thank you.
And what we're hoping to do is to set up limited liability community multi-stakeholder platform cooperatives, and I can go into detail about that for tomorrow for those who need to know. And we will be putting up a result of whatever comes out of tomorrow. It's not just me making a presentation, by the way. I need to involve people in what you believe are the three most important changes you want to see in our society right now in the next 3 years at the maximum. So if we gather all your ideas together, we then have an agenda 2026 to put in place instead of agenda 2030.
Another question over here. Thank you, Chris.
Sounds very timely what you're doing, Chris, and we've actually already set up a community benefit society. Along those lines, one of the aspects of it is that it kind of has this feature of having a statutory lock-in system. My intention with that was to acquire, so you could acquire land and property and protect it, so it's never then sold off for profit, so it's protected for the community. But I still have questions about the jurisdiction of it, because you still are registering it with the government, and it's in the legal, unless it's the same, we're talking about the same thing, it's not going to be in the private, so you are still operating in the legal, which makes you very vulnerable to changes in legislation. And as we've found out from Sandy, we know where this thing is going, so you're very vulnerable with that structure, even though I think it is the very best one as a structure to offer. But could that be done in the private?
I don't think it puts us into a difficult position. I think we are using their system against them for the first time corporately. And it is that issue that is so important. I have run national and international corporate bodies, various companies and things in the past. And I know that if we turn it to our account, we can beat them at their game. And that's the important bit from us. If we are quite clear, we are doing this for the benefit of the people, governments of the people, by the people, for the people, not a corporation which is government of the people, by an elite, for the bankers. And we need to change that process. And this is a simple structural way which has been provided to us on a plate by them when they don't know it, and we start to use it for our benefit.
Yeah. Thank you. Brilliant.
Thank you. Last question, probably, on this bit. Round the corner somewhere. Is that you, Andrea?
I have a question. There's already an organization called CABI, Communities Assemblies of British Island. I think they already are around the world, having the same approach as yours. Have you thought about maybe come together or something like that?
Yeah, well, this is the purpose of it. There are a lot of organizations that are working in this area effectively, and we need to make sure that we're all focused on the same thing and have a firm basis from which to work. If you set up a private members association, there is no limited liability. They can come at you and take all your assets completely. But these people have realized that 200 years ago and set up limited liability things. So it's very important that CABI and others, we work together, understanding clearly the structural basis on which we can really have an effect and bring about change in a very short space of time. I just wanted to bring in one thing which I forgot to mention this morning. If the king is the commander-in-chief, and the Prime Minister has to go to the King in order to, or the Commander-in-Chief to give the order to go to war for all our forces. All he or she, as it was in the case, has to do is to sign a piece of paper saying, yes, okay, here's the order to go to war, to go to active service, and so off we go. They never actually do the opposite, which is here is the order to stop killing, to stop the war. They can do that in a few minutes. But even more than that, if, for instance, we put a new system in place where the king in Privy Council and the Prime Minister has to check on the legality of the stuff, the king can say, when the Prime Minister comes to them and saying, we want to go to war, he can say, no, I am bound by law to ensure that the only occasion when we can use armed force under Section 50 or 51 of the UN Charter is if we are under attack from the armed forces of another state. Until then, I am forbidden by law from signing this document. Now, if that one system took place and we recalled all the current RAF, Army, Navy, SAS, MI6, MI5, all the rest of them, back to the UK to stop doing what they're doing, we could change war in a matter of hours or weeks at the most. No more war in this country. So let's find the key systems that we can put in place that will force massive change throughout this country very quickly to our benefit.
Thank you very much, Chris. So if you want to work more on this subject with us tomorrow, 11 o'clock here, bring a bit of lunch to share until 2:30. And just this sounds a little prosaic compared to what you have been talking about, but a little question. The Clearfield Doctrine, the American doctrine, which if a government acts as a commercial entity, acts as a business, then they forfeit their ability to govern. Have any of you got any thoughts on that?
I think the Clearfield Doctrine applies to the US, not to the UK. However, the UK is a limited company and it has a Dunn's registration number, Dun & Bradstreet, as do most corporates operating in the UK. Therefore, they've registered on US soil, so surely US rules and regulations should apply to them if they're regulated in the US. And therefore, I believe, I've yet to have my mind changed on it, that the Clearfield Doctrine does apply to the UK, not per se, but to corporates that are UK corporations that are also registered on Dun & Bradstreet in the US.
Very interesting, thanks. And then Glyn's...
Quick addition to that, it's very important to realise that although that's what the law says, they don't abide by it. And our problem really is making sure they abide by our laws. For instance, the renouncing war, never threatening to use force and so on. We've got to force them to uphold and enforce the law all the time. And the Clearfield Doctrine is not being applied, and they will find ways around applying it all the time.
Makes sense. And Glyn's question, what if the Southwest region community-funded class action is taken out against regional authorities to affirm corporation-to-corporation relationship required for council tax invoicing?
Thank you.
Yeah.
Initial thoughts on that. You're talking corporate to corporate. It'll get kicked down the road. The can will be kicked down the road
Same
for
sort
years
of thing.
and nothing will
Can't
happen.
enforce it. No enforcement.
When I started out on this journey many, many years ago, I realised two things. Personal jeopardy and trial by public. When I mean personal jeopardy, I mean you'll have had letters, documents, demands, and they'll all be signed off with the company name. Even solicitors now don't put the name of the solicitor, they put the firm's name. Even in handwriting, they'll sign it like a signature, but it's the firm's name. A firm does not make any decisions, a bank does not make any decisions, they're just buildings where people work. An individual has had to come to the mindset to put that into writing and send it to you, having made the decision. That's the person you need to go for, and if they've broken the law, the personal jeopardy, i.e. loss of liberty, funds and jobs, should lie on the person who has done the wrongdoing against you, not the corporation. And we've got to get a mindset of identifying these people, find out who wrote you the letter, find out whose name, who made the decision that caused you harm, loss or injury, and take them to task. That's personal jeopardy. Trial by public is what we're doing here. We're putting out to the public. We've heard from Sandy just now, I could listen to her all day long, all about how they've made all these decisions without any public consultations, without even the MPs knowing about it. No, that's wrong. We should all know about it. Trial by public is that the public make the law, which I said earlier, and the public have a right to know everything, and when they know everything, make an informed decision and elect that decision to be operated on, not dictated to.
Thank you.
One quickly.
Glyn's just going to say something, I think.
May I just add a little bit of a spin inquiry on that? What happens if we did, as a Southwest region, have a class action taken out to demonstrate that, and on that basis held back, maybe in trust, the council tax until such times that is... So that could go 2, 3, 4 years down the line. So it wasn't in terms of policing. It was more about a tactic to say, as this is going through the legal process, we have grounds to withhold until findings are provided.
My personal view on that was I would think that you would have lawful excuse to do so. Lawful excuse.
So
if
we got together as a group and put a class action to it, what you're doing is you're saying, we think this is a problem, we're withholding funds until it is sorted out.
I would certainly think you've got an argument for lawful excuse to do such a thing. Okay. You'd have to present that as your argument, but I think lawfully speaking, I think you're not breaking the law, you're not refusing to pay, you're asking the questions of the things that we talked about earlier, like the Fraud Act, where they're withholding the information. You have a right to know where your money's going, where it's going. So if
you're putting something in process.
You're putting something in process.
And the onus is on
process.
And the onus is on them to come back and close that appropriately.
The onus is on the accuser, so the onus would be on you to prove your point, and the onus would be then on them to rebut that point. And whilst that process is going on, you have a good lawful excuse. You may find that you'll get resistance, but I do not think you would be breaking any laws by putting it forward as lawful excuse.
Yes.
Can I just make a point about class actions? This is in the civil area and not the criminal area. And what I've been trying to point out all the time is if you charge somebody with a criminal offence under the Rome Statute of the International Criminal Court or the International Criminal Court Act, both of which are on the back of that sheet of paper, they could be put in prison for 30 years. And that is a very powerful thing. So if we get one of our leaders, such as Tony Blair or Boris Johnson or Keir Starmer, prosecuted under these criminal laws, which they have been breaking all the time, and one of them is convicted, that will reverberate right around the world and apply to every civil servant in this country, whether local, national, regional government or not. So go for both, but it's a much longer route to go for a class action than it is to get a criminal prosecution going in relation to one or two key politicians.
So that's one for the county or this region to think about, to go for both.
Most certainly.
Go for both, and the delaying tactic could be to the advantage of withholding legally. That then puts pressure and leverage on the authorities to make remedy.
Yeah, I think it's always been a question of if you get it in the civil courts are a fight for monetary gain. That's where the money is, that's where the compensation is. Justice is in the criminal court, where if you have got clear evidence of somebody committing a crime, then they must answer for that. The onus of proof is upon you as the accuser, but if you've got robust and strong evidence, I would take it through the criminal court. Now, there's a caveat on that if you do a private criminal prosecution, the CPS can step in and take it over, and you know what's going to happen then. It's back in the corporate entity. My way of dealing with it is take it to the magistrate's court, but before you do that, make sure it ticks all of the boxes for being in the public interest, because their get-out clause is usually it's not in the public interest to prosecute. Now, there are a number, I think it's 5 or 7 points to prove if it's in the public interest. And if it's not in the public interest, they've got a very good reason to not run a prosecution for whatever, and that's how they get away with it. So what I tend to do is serve the CPS with a formal notice instructing them that it ticks all of the boxes that require public interest intervention. That negates their ability to stop any prosecution. Then you offer it to them or you go privately. And you can do it privately for nothing through the magistrates to start with. If it's got an imprisonable offence more than 6 months in prison, it's got to go to Crown. But the start of it is always in the magistrates' court where they plead guilty or not guilty, and then it gets forwarded to Crown to deal with.
One more quick addition to that, and that is there is a unit in New Scotland Yard called the War Crimes and Crimes Against Humanity Unit, who are specialists, supposedly, in bringing these things. So make sure, if you go into your local police station and report our leaders for crimes of conduct ancillary to genocide or war crimes, make sure the local police know that it has to be passed on to that unit at Scotland Yard. If there's one unit dealing with it, we're in a much better position to prove all those points that you've just made.
Thank you very much to Dave.
One important thing on this is, has anybody been to the police before and they've not recorded something as a crime when you've known it's a crime? Yes. That's not allowed. Look up the thing called the Home Office Counting Rules. The Home Office Counting Rules specifically state that a policeman who has a crime recorded to them must, and I mean must, record it and give a crime reference number unless they have irrefutable evidence to the contrary that it didn't happen. And that is even if you want to remain anonymous. If they can't prove it didn't happen, they have a lawful duty to record it under Home Office rules. And if it's a bit dubious, the Home Office rules continue on to say that the victim's story should always take precedence first to prevent harm, loss or injury, and therefore the police should take you seriously, even if it sounds a little bit crazy. But the main thing you've got to take away is when you report something to the police, quote the Home Office Counting Rules, they must record it as a crime unless they can prove it isn't.
That's very powerful. Thank you so much, all three of you, for fielding all these questions. Thank you.